Hi everyone, my name is Shazia Khan, and today's unit that we'll be doing is the final session, and it's the assignment discussion session for company law unit. And firstly, before I go into the elements of the assignment, I want to give you a summary of the actual unit itself, and then go through quickly through the learning outcomes so you have a better idea, and then go through the assignment. So this, the company law unit aims to provide learners about English law related to things like registering companies, including private and public limited companies. Learners will gain a knowledge and understanding about the legal issues affecting companies and the rights and obligation of shareholders and directors of the legal procedures related to corporation liquidation. So now I'm going to go into learning outcome 1 and quickly go through what each learning outcome is so you have a better idea before going into the assignment brief. So learning outcome 1 is to understand legal issues affecting companies through the analysis of characteristics in corporation functions and regulatory frameworks. And we went into learning outcome 1, which was the indicative content, to look at characteristics of the sole trader, partnership, public and private companies, to look at the functions and regulatory framework of company law, to look at theory and policies and issues of company law and corporate objectives, to look at the corporate veil, judicial and statutory lifting of the corporate veil, and also to look at articles of association in regards to this. So we went on to look at 1.1, which is to analyse the characteristics of the sole trader. So we looked at elements of the sole ownership, we looked at unlimited liability of sole traders, direct control and ease of formation. We then went on to look at the taxation issues in regards to how they are taxed, sole traders, the limited resources and the limited continuity and privacy for sole traders. We went on to do the same. We went on to look at partnerships and how it's structured and how their profits and losses are structured, so how each partner deals with everything and who has the authority. We went on to look at unlimited liability within partnerships, and we went on to look at partnership agreements and again look at the issue of taxation for partnerships. We looked at the ease of formation, so how easy it is to establish a partnership and the legal formalities within that. We also looked at the continuity of partnerships and how it can be affected in partnership changes, such as composition and admission. We then went on to look at the shared management, so how partners generally have the right to participate in the management, shared and decision-making processes. We then went on in learning outcome to look at public and private companies and looked at their ownership, the number of shareholders for public company. We went on to look at first public companies. We looked at public companies are subject to disclosure requirements. We also looked at are subject to regulatory oversight by such as, the Securities and Exchange Commission, SEC, and the Financial Conduct Authority within the UK, which is FCA. We also looked at the public companies and how they have corporate governance and how that applies to them. We then went on to public companies have access to capital markets for raising funds. We went on to liquidity of shares of public companies and the market valuation. So public companies are determined by the stock market. We then went on to private company, which we looked at the ownership of a private company, the number of shareholders, and the disclosure requirements. We then went on to regulatory oversight of private companies and corporate governance and access to capital. We then finally went on to looking at the liquidity of shares in private companies and ownership controls of private companies, where they have greater controls of private companies. We then went on to 1.2, which was to evaluate different functions of EU companies. And we looked at the EU function and the market integration. We then went on to look at trade and investment within EU companies, innovation and research. And we went on to look at employment and social functions. We then went to look at corporate governance and responsibility and compliance and regulation and international competitiveness. We then went on to 1.3, which was to evaluate regulatory frameworks of incorporation of UK and EU companies. And we looked at the regulatory frameworks, and we looked at the legal structure and requirements of UK companies and then EU companies and compared them. We went on to look at the incorporation procedures for UK companies and EU companies. We then went on to look at the share capital and liability of UK companies and EU companies, and it was a comparison. We then went on to the corporate governance and reporting for UK companies and EU companies, and we went on to look at cross-border operations for UK companies and EU countries. We then went on to 1.4, which we looked at evaluating the articles of association and how these can be enforced. And the importance of articles of associations. We looked at the content of articles of association, so what it contained within an article of association, and we looked at it had governance structure, share capital, decision-making procedures, management powers, amendment powers and procedures. Also, we looked at the enforceability of articles of association, so the legal basis, statutory framework, shareholder agreements, and then we went to look at things like the director's duties within the articles of association and the shareholder's duty and any sort of dispute resolution for resolving any disputes. We looked at the significance and importance of articles of association, so internal governance, investor confidence, and legal compliance. We then went on to look at flexibility and adaptability and conflict resolution for articles of association. And finally, we looked at 1.5, which was to analyse the effect of corporate veil and how this can be lifted. And we looked at what the issue was around corporate veil. We looked at the effects of the corporate veil, again, looking at limited liability protection. We looked at encouraging investment. We looked at separate legal entity and business flexibility. We then went on to look at the circumstances for lifting the corporate veil, things like, fraud or wrongful conduct, where the courts may lift the corporate veil to hold individuals personally liable for any sort of fraudulent or wrongful conduct. We looked at the agency or alter ego. We looked at undercapitalization. So where a company lacks sufficient assets to meet its foreseeable liabilities, and how the courts can pierce the corporate veil to protect creditors and ensure that fairness is being done. And then we looked at group of companies, so in this case, corporate structures of groups of companies and how the courts may pierce the corporate veil in regards to preventing it, again, any sort of injustice or unfairness, and we looked at that in regards to the courts having the power to do that. We then went on to look at methods for lifting the corporate veil, and we looked at the director's liability, where directors can be held personally liable for their actions or omissions. We looked at shareholders' liability, and we looked at the court intervention. So this was learning outcome 1. We then went on to look at learning outcome 2, which is looking at understanding the rights and obligations of directors within an organisation. So we looked at the indicative content, which is directors' duty, derivative actions and minority shareholder remedies, rights of shareholders, the company's constitution, directors' responsibilities to creditors, and we looked at disqualification of directors. And there are videos on there that you could go and look at in your own time in regards to the area that we're working on. So we looked at 2.1. We looked at evaluating the legal nature, roles, powers and liabilities of shareholders and directors towards the company. So we looked at the legal nature. So shareholders are the owners of the company holding equity interest in the business. We looked at the roles of shareholders and the key roles that they play. We also looked at the powers of shareholders where they have the power to vote on company resolutions of general meetings. We also looked at the liabilities of shareholders. So they're generally limited to the amount they have invested in the company's share. We then went on to look at the legal nature, roles, powers, and liabilities of directors. So we looked at the legal nature of directors and how they are appointed by the shareholders to manage the company's affairs. We went on to look at the role of directors and how they have key roles and responsibilities. So they oversee the key company's operations. They look at deal with the strategy and performance of the company. We then went on to look at the powers of the directors and how they manage the company's affairs, subject to restrictions posed by the company's articles of association. We looked at the liabilities of shareholders, directors, and they have own fiduciary duty to the company and shareholders. We then went on to 2.2, which is assess the consequences to the breach directors' duties in the company law. So we looked at legal consequences for directors, so personal liability. Directors who breach their duties may be held liable for any losses incurred by the company or its stakeholders. We also look at the fiduciary duty breach. So breaching fiduciary duties such as duty of loyalty, care, and good faith can result in legal action against directors for breaching of trust or their fiduciary duty. We also looked at the disqualification. So in serious cases of misconduct or negligence, directors may face disqualification from serving as directors of any company for a specified period. We also looked at the criminal sanctions. So directors who engage in fraudulent, dishonest, or criminal conduct may be subject to criminal prosecution under company law or related statutes. So criminal sanctions may include fines, imprisonment, or other penalties. We then went on to look at the financial consequences, financial penalties directors are liable for, and the loss of assets. We looked at the reputational consequences, so damage to reputation. So breaching director duties can damage the director's professional reputation and credibility. And we looked at the loss of trust as well in regards to stakeholders, including shareholders, employees, and customers, etc. We then went on to 2.3, which looked at analysing the director's responsibility to creditors of the company in the financial distress. We looked again at the fiduciary duties to act in the best interest of the company. We looked at the duty of care and skill, so that directors must exercise reasonable care, skill, and diligence in managing the company's affairs, and looked at financial distress, how it entails taking appropriate steps to preserve the company's assets and maximise creditors' recovery. We then went on to look at preferential treatment prohibition, where directors are generally prohibited from giving preferential treatment to certain creditors. We also looked at avoidance of wrongful trading, where directors must take care to avoid wrongful trading, which occurs when they continue to trade the company while knowing or should have known that it is insolvent. We went on to look at duty to consider creditors' interests. And then we went on to look at insolvency proceedings. So if the company becomes insolvent or is at risk of insolvency, directors have a duty to take appropriate action to protect creditors' interests. And we looked at finally at avoidance of fraudulent transactions. We then went on to look at 2.4, which is to analyse the mechanism for disqualification of directors. And we looked at statutory disqualifications in the UK, so whether they've breached their fiduciary duties or any legal obligations. We also looked at disqualification orders are typically sought by regulatory authorities. We then went on to look at voluntary disqualification, where the directors may voluntarily resign or agree to be disqualified from serving as directors if they acknowledge their misconduct or unfitness for the role. We went on to automatic disqualification. So in some jurisdictions, they have provisions for automatic disqualification of directors in certain circumstances without the need for a court order. We then went on to look at civil penalties and sanctions. So in addition to disqualification, directors may be subject to civil penalties. We also look at period for disqualification for directors. And then we just looked at the period, which was typically the duration, the disqualification periods, where it may vary depending on the severity of the misconduct. So this was learning outcome 2. We then went on to learning outcome 3, which was to understand the rights of shareholders and minority shareholders. So we looked at 3.1, which is to analyse the rights of shareholders in public and private limited companies. So we looked at the right of shareholders, firstly, in public limited companies, where they have the transferability of shares. So shareholders in public limited companies typically have greater flexibility in transferring their shares. We looked at the liquidity of investment for public limited companies. We then went on to look at voting rights for public limited companies, the access to information for public limited companies, and the dividend rights for public limited companies. We then went on to look at the rights of shareholders in private limited companies. Again, we looked at the transfer restrictions, where shareholders in private limited companies may face restrictions on the transfer of their shares. We looked at limited liquidity, where the shares in private limited companies are less liquid compared to those in public limited companies. And then we looked at the voting rights in private limited companies. We then went on to look at the limited access for private limited companies, where they've got limited access to information compared to public company counterparts. We then went on to the dividend distributions in private limited companies that are determined by the company's management and the shareholders. We then went on to look at 3.2, which was to explain the rights of members in voting. So we looked at the general voting rights. So members of both public and private limited companies have the fundamental right to vote on significant matters affecting the company. We went on to look at ordinary resolutions. So members' voting rights are exercised through resolutions passed at general meetings of the company. And then we looked at special resolutions. So certain decisions require a special resolution, which typically requires higher threshold of votes to pass. We then went on to look at proxy voting, and we went to look at electronic voting too. And we looked at voting by show of hands against poll. So in general meetings, voting can be conducted either by a show of hands or by a poll. We then went on to look at 3.3, which is to analyse minority shareholder protection. We looked at minority shareholder protection, where it refers to the legal safeguards and mechanism designed to protect the rights and interests of minority shareholders in a company, particularly in situations where they are vulnerable, oppression, unfair treatment, or abuse by majority shareholders or company management. We went on to look at the legal framework for minority shareholders, and we then went on to look at the rights of information and inspection. So minority shareholders typically have the right to access information about the company, including financial reports, annual reports, minutes of general meetings, and other relevant documents. We then went to look at the protection against oppression. So minority shareholders are entitled to protection against oppression or unfair treatment by majority shareholders or company directors. We then went on to minority veto rights, and we then looked at derivative actions. So where minority shareholders have the right to bring legal action against the company or its directors on behalf of the company, known as derivative action, if they believe that the company's interests have been harmed by wrongful conduct or breaches of fiduciary duty. We then went on to look at exit rights and remedies. So where minority shareholders have some exit rights or remedies available to them if they are dissatisfied with the company's management or direction. These exit rights may include the right to sell their shares back to the company at a fair price, seek judicial remedies for oppression or unfair prejudice, or pursue alternative dispute resolution mechanisms to resolve conflicts with majority shareholders or company's management. So we completed learning outcome 3 there. Okay, now we're going to go on to learning outcome 4. And in learning outcome 4, we're looking at understanding the legal procedures relating to the corporation liquidation. The indicative content would look at directors' responsibilities to creditors, corporate governance, and the legal procedure relating to corporation liquidation, the differences between administration and liquidation of the company. So we looked at 4.1, which was to evaluate the role of auditors, what an auditor is, and how they would deal with liquidation. We looked at independent verification, where auditors would provide independent verification of the company's financial statements, ensuring that they present a true and fair view of the company's financial position and performance. We then went on to look at assessment of going concern, so how auditors assess whether the company is a going concern, meaning it has the ability to continue operating in the foreseeable future. We also looked at detection of fraud and misconduct, where the auditors are responsible for detecting and reporting fraud, errors, and misconduct that may impact the company's financial statements. We then went on to look at review of asset and realization and distribution, so where auditors review the realization of the company's assets and the distribution of the funds to creditors and shareholders to ensure any sort of compliance with legal requirements and equitable treatment of stakeholders, and how they assess the fairness and accuracy of assets, evaluations, sale proceeds, creditor claims, and shareholder distributions, providing assurance that funds are distributed in accordance with strategic priorities and the company's articles of association. We then went on to look at compliance with legal regulatory requirements, so auditors ensure compliance with applicable legal and regulatory requirements governing financial reporting, disclosure, and corporate governance. We then went on to look at communication with stakeholders, so how auditors communicate with stakeholders, including shareholders, creditors, regulators, and liquidators, providing assurance regarding the accuracy and reliability of financial information and the integrity of the liquidation process. We then went on to 4.2, which looks at analysing the winding up process and the dissolution, including powers and duties of liquidators. We looked at the winding up process and what it involved, including the powers and duties of liquidators, involves understanding the legal framework and procedure steps involved in winding up a company's affair. So we looked at the commencement of winding up, which is winding up may commence voluntarily by the shareholders or directors of the company, or involuntarily through a court order. We then went on to look at the appointment and powers of the liquidator. So upon commencement of winding up, a liquidator is appointed to oversee the liquidation process. The liquidator may be a licensed insolvency practitioner or an official receiver appointed by the court. We then went on to look at the realization of assets, where the liquidator identifies, collects and realizes the company's assets, which may include cash, property, inventory, equipment, and intellectual property rights. We then went on to look at the settlement of liabilities, so where the liquidator assesses the adjudicator's creditors' claims, determining the validity and priority of each claim. We also looked at the distribution of funds. So we looked at once the company assets have been realized and its liabilities settled, the liquidator distributes the remaining funds to creditors and shareholders in accordance with their entitlements. We then went to look at the finalization and dissolution. So after all assets have been realized, liabilities settled and distributions made, the liquidator prepares final accounts and reports detailing the liquidation process. We then went on to look at 4.3, which is assess the priority of creditors in winding up process. And here we looked at secured creditors who hold security interests or charges over specific assets of the company, such as property, equipment, or inventory. We then went on to look at the preferential creditors, who are entitled to priority payment over unsecured creditors, but rank behind secured creditors. We then went on to look at unsecured creditors, who are creditors who do not hold security interests or preferential status, and therefore entitled to be paid from the company's remaining assets after secured and preferential creditors have been satisfied. We then went on to look at subordinated creditors, and these are creditors who have agreed to subordinate their claims to those of other creditors, typically through contractual agreements or subordination provisions in the loan agreements or bond indentures. We then went to look at shareholders, and these are the owners of the company, and they rank last in the hierarchy of credit claims. We then went on to 4.4, which we looked at evaluating the role of licensed insolvency practitioners. We looked at how they play a crucial role within the insolvency and liquidation processes. We looked at their expertise and qualifications. We looked at the appointment and oversight, so how they are appointed to oversee insolvency processes, including administrations, liquidations, and voluntary arrangements. We looked at the role in administration, so how they act as administrators, assuming control of the company's affairs and implementing any sort of restructuring plans. We then went to look at the role in liquidation, so how they act as liquidators, responsible for winding up the company's affairs, realizing its assets and settling its liabilities and distributing funds to creditors and shareholders. We looked at the protection of shareholders' interests. We also went on to look at communication and transparency, how throughout the process they are providing updates on developments and seeking input on key decisions and addressing concerns and queries. We also looked at conflict resolution and mediation, how they negotiate and mediate disputes between stakeholders to reach a mutually acceptable resolution, and how they use their expertise in insolvency issues. So we've looked at a quick summary of learning outcome 1, 2, 3, and 4, and looking at the elements of the learning outcomes. And now we're going to go on to looking at the assignment brief in regards to the unit company law. So this quick summary will help you identify elements of the assignment brief, so which we'll be going through now. So you've got an idea of where you need to look to complete each task. So the company law assignment is a level 7 diploma in international business law. The assignment brief is a unit level 7, number of credits 20 credits, and the unit aims to provide, again, learners to look at the law relating to companies in private and public limited companies, and learners will gain knowledge and understanding of the legal issues. And as we've gone through the learning outcomes, 1 is to understand legal issues affecting companies through the analysis of characteristics, incorporation functions, and regulatory frameworks, and the assessment criteria, which we looked at when we went through the learning outcomes. So 1.1 is to analyse the characteristics of sole trader, partnership, private and public companies. 1.2 to evaluate different functions of EU companies. 1.3 to evaluate regulatory frameworks of incorporation of UK and EU companies. 1.4 to evaluate the articles of association and how these can be enforced, and 1.5 to analyse the effect of corporate veil and how this can be lifted. We also looked at learning outcome 2, which was to understand the rights and obligation of directors. We looked at 2.1, which is to evaluate the legal nature, roles, powers and liabilities of shareholders and directors towards the company. 2.2 to assess the consequences of a breach in directors' duties in company law. 2.3 to analyse the director's responsibilities to creditors of the company in financial distress. 2.4 to analyse the mechanisms for disqualification of the directors. We then went on to learning outcome 3, which is to understand the rights of shareholders and minority shareholders. We looked at 3.1, which was to analyse the rights of shareholders in public and private limited companies. We went to 3.2 to explain the rights of members in voting. 3.3 to analyse minority shareholder protection. And finally, we looked at learning outcome 4, which was to understand the legal procedures relating to corporation liquidation. We looked at 4.1 to evaluate the role of the auditor. 4.2 to analyse the winding up process and dissolution, including powers and duties of the liquidator. 4.3 to assess the priority of creditors in a winding up process. and 4.4 to evaluate the role of licensed insolvency practitioners. So there's 4 tasks, okay? So the first one, task 1 of 4, the unit learning outcome 1. So this involves learning outcome 1. So you need to understand legal issues affecting companies through the analysis of characteristics, incorporation functions, and regulatory frameworks. Make sure that when you are doing this assignment, you are put the unit heading on at the front cover. You could have a contents page with what elements you're doing. Make sure that you are, if you are doing each task, make sure you have it as a heading, that you are completing different parts of the task, so it's clear for the reader, for the marker to understand that you've completed every element of learning outcome 1. And make sure you are using Harvard referencing. So the assigned task criteria to be covered: 1.1, 1.2, 1.3, 1.4, 1.5. The assignment brief and guidance. So Christopher and Ray are setting up a business online that will sell goods to the UK and to the EU. Christopher wants to set up an incorporated business, whilst Ray wants to set up an unincorporated business. Christopher argues that they would be better protected if their business was incorporated, and they would be able to establish their business with clear organizational structures. Ray argues that any protection can be stripped away and that the regulations around incorporations are too complicated. He also argues that it would be very difficult to change the nature of the business, as once it created, it is set in stone. They have asked for you to write a report highlighting the issues above. You must ensure that you analyze the characteristics of the sole trader, partnership, and public limit private companies. So this would be in your task 1, number 1, and the heading would be analyze the characteristics of each one of them and write below about each one. So it needs to be as a heading, so it identifies you've done the number 1 bit, okay? Number 2, which is a separate part, you need to evaluate the different functions of EU companies, and that would be a heading in itself. Number 3, evaluates regulatory frameworks of incorporation of UK and EU companies, and that would be a separate heading. And then number 4 evaluates the articles of associations and how this can be enforced. That would be a separate element. And then number 5 analyzes the effect of corporate veil and how this can be lifted. This is all to do with learning outcome 1. So you need to put that as a heading, learning outcome 1. There are 5 parts within learning outcome 1, and you need to make sure that each part is a heading, and then you answer the question under the heading, so it's clear. In this, learners must show that they have an understanding and knowledge of the subject area. They must provide references to relevant case law or legislation where appropriate, and be able to support your answers and show evidence of wider reading appropriately. And this must be, you must use Harvard referencing system. The delivery and submission for task 1 is the submission is in the form of a report written in a Word document. The recommended word limit is 1,000 words, excluding diagrams, references, and appendices. Learners are expected to adhere to the word limit. A 10% leeway either side of this range is permitted before the assessor is instructed to stop reading any further. So literally for each one, you need to do about, because there's within what task 1, there's 5 parts, so do about 200 words for each part, and you have that 10% leeway as well. But make sure you don't go over the word limit as well, because they've given you a guidance of how many word limits to look through. The referencing for task 1 is to use and cite case law, academic resources, and again, comprehensive use of Harvard referencing. So this all needs to be in one document. So all 4 tasks need to be in one document, so not 4 separate documents. Then we go on to task 2 of 4, which is looking at unit learning outcome 2. So understanding the rights and obligation of directors. All this is in your slides as we've been going through. Task assessment criteria to be covered: 2.1, 2.2, 2.3, and 2.4. The assignment brief and guidance. So you have been contracted as a consultant to a business which operates as a partnership. The partners are considering converting their business to a limited company. You have been tasked in producing a report which will help the partners to understand the rights and legal obligations of directors of limited companies. The partners have specifically asked you to do a report on the following. Number 1, which is an evaluation of the legal nature, roles, powers, and liabilities of shareholders and directors towards the company. Number 2, an assessment of the consequences of breaching directors' duties as stated in company law. Number 3, an analysis of the directors' responsibilities to creditors of the company who are in financial distress. And number 4, an analysis of the mechanisms for the disqualification of directors. Again, this is covering 2.1, 2.2, 2.3, 2.4. So within task 2, you have 4 elements. Each of these elements, whilst you're talking about them, needs to be in a heading. So if you're talking about number 1, you need to have an evaluation of the legal nature, roles, and liabilities of shareholders and directors towards the company as a heading, and then write about that. The same for part 2, part 3, and part 4. So there's 4 elements of task 2, and they cover learning outcome 2. Learners must show knowledge and understanding of the subject area. You must provide references to relevant case law or legislation wherever appropriate, and you must be able to support answers and show evidence of wider reading appropriately. Again, the submission is the way of a report in a Word document, so it all needs to be in a Word format. Okay, and all the tasks need to be on one document. The recommended word limit is 1,000 words, excluding any diagrams, references, and appendices. Learners are expected to adhere to the word count, and again, a 10% leeway either way of this range is permitted before the assessor is instructed to stop the reading. So if you look at this, there's 4 parts to task 2, and you need to have a heading for each part. Make sure that you do it about 250 words for each bit of the tasks. For referencing, you should cite a range of case law, academic, and reliable sources again, and a comprehensive Harvard referencing style must be included. Again, you need to be consistent with how you're doing stuff, so make sure you are made it clear that's task 1, task 2, and each part of task 2, and make sure it's a heading so that it's clear as you know, and make sure it's an academic piece of work and you are using Harvard references as it is a level 7 piece of work. Now we're looking at task 3 of 4. So unit learning outcome is task 3, is unit learning outcome 3, to understand the rights of shareholders and minority shareholders. So the task assessment criteria to be covered is 3.1, 3.2, 3.3. So the assessment brief and guidance. So this is task 3. So the partners from task 2 are also debating whether to remain a private limited company, which is an LTD, or plan to become a public limited, which is a PLC. They are aware that there are different rights of shareholders dependent on whether a business is limited or a PLC. To help clarify their understanding of shareholders and their rights, they have further tasked you to produce a report which will include the following, which is number 1, it analyses the rights of shareholders in public and private limited companies. Number 2, explains the rights of members in voting. And number 3, analyses minority shareholder protection. So within task 3, you have 3 parts to do, and make sure they're all under headings, and make sure when you do them under headings, make sure you start writing under the headings, okay? In this, learners must show knowledge and understanding of the subject area. You must provide references to relevant case law and or legislation wherever appropriate. You must be able to support answers and show evidence of wider reading appropriately. Delivery and submission. So the submission, again, is in the form of a report written in Word format. The recommended word limit is 1,000 words, excluding diagrams, references, and appendices. So you've got 3 parts to task 3, and you've got to do it within 1,000 words. So 350 words each, around that. And learners are expected to, again, adhere to the word count, and a 10% leeway either side of this range is permitted before the assessor is instructed to stop reading any further. The referencing, again, you should cite a range of case law, academic and reliable sources. you should use a comprehensive Harvard-style list, must be included in the end of your work. Finally, the task 4 of 4. So the unit learning outcome is 4, which is to understand the legal procedures relating to corporation liquidation. So task assessment criteria to be covered is 4.1, 4.2, 4.3, and 4.4. So here the assignment brief and guidance. So you are to write an essay which is focused on the legal procedures relating to the liquidation of an incorporated business. So that is the task 4 part of it. You must ensure the essay, number 1, evaluates the role of the auditor. Number 2, analyzes the winding up process and dissolution, including powers and duties of liquidators. Number 3, assesses the priority of creditors in a winding up process. Number 4, evaluates the role of licensed insolvency practitioners. The learners must show knowledge and understanding of the subject area. They must provide references to relevant case law or legislation that is used wherever appropriate. They must be able to support their answers and show evidence of wider reading appropriately. And the delivery and submission. So the submission is in the form of an essay, and it's in Word document. The recommended word limit is 1,000 words, excluding diagrams, references, and appendices. So you've got 4 parts to task 4, so 250 words each. Learners are expected to adhere to the word count. 10% leeway either side of this range is permitted again before the assessor is instructed to stop reading any further. Again, referencing, you should cite a range of cases, academic and reliable sources, and a comprehensive Harvard referencing list must be included. So these are the tasks that you've got. So you've got 4 tasks. Within 4 tasks, you have each element which you need to have as a heading. So that is clear for the marker who's marking it that you are doing each part of each task. Each task refers to each learning outcome. So task 1 to learning outcome 1, task 2 to learning outcome 2, task 3 to learning outcome 3, and task 4 to learning outcome 4. You need to make sure it's all done on one document, and it is Word document. So you need to make sure that it's you've got task 1, task 2, task 3 on one document and submit it as one document. Make sure you are doing your Harvard referencing. Make sure you are putting your headings in for each part that you are doing for each task, and make sure you are fully citing cases and referencing everything properly. Once you've completed the assignment, it gives you the word count. Please do not exceed the word count, otherwise you will be penalized. And make sure you stick to the guidance that is provided for you, the word limits and things like that. And once you have completed the assignment, you need to make sure you are submitting it on Learner Work at ukvarsity.co.uk. And if you have any questions about the assignment or any tasks, or if you're unclear about anything, please again email learnerwork@ukvarsity.co.uk. Make sure, again, just to clarify, you are doing the tasks, task 1, 2, 3, 4, and each element of each task, as in 2.1, 2.2, 2.3, and this 4 or 3 elements, however much they are, that you are following that and doing them as a heading and then writing under that, okay? And make sure it's an academic piece of work, and make sure that you provide references again, and make sure, again, I'll reiterate this, that it needs to be a one piece of document, and make sure you have your name on it, the unit title, and make sure you are sticking to the word count, because that is really important, because otherwise you will be penalized for that. Again, really important, Harvard referencing. Make sure that you are using academic sources and reliable sources, and when you are using these sources, make sure that you are using the Harvard referencing style of referencing at the end of the work, okay? So it's right towards the end. So once you've done task 1, 2, 3, and 4, you will put the final Harvard referencing towards the end, okay? You need to make sure it's an academic piece of work, the structure and the flow and the format is not confusing for the marker. So that's why I was saying that each task needs to be clear, that you've done task 1, 2, 3, and 4, and within that you've done each element which's got heading. So if there's any questions, again, learnerwork@ukvarsity.co.uk. Thank you for attending today's session, and this is the final session on company law, which is the assignment discussion session. Thank you once again.